Bismillah ar-Rahman ar-Rahim. Respected colleagues and friends and the organizers of this conference, Assalamu alaikum. My name is Dr. Tariq Hassan. I'm a forensic psychiatrist based in Canada, and I'm an associate professor with Queen's University, and I'm also the chair of the Forensic Directors Group for the province of Ontario. I'm very happy and privileged to be presenting to you today, and I thank you for taking the time to listening to my presentation. Forensic psychiatry in Pakistan has reached a very critical point, and especially with the recent Supreme Court judgment has shown that now is the time forensic psychiatry in Pakistan must take a step into the future. My talk today will be divided into three parts. The first 10 minutes, I will go over some of the key concepts of forensic psychiatry, how it has currently been practiced. The second 10 minutes will be around the Supreme Court judgment, the Safiya Banu case, and the landmark judgment, how this will impact forensic psychiatry in Pakistan for at the very least the next couple of decades. And my third part of the talk, the last 10 minutes, I'll be presenting to you an opportunity I have to develop a training program for different departments of psychiatry within Pakistan. So I'll be putting together a special request, especially to the heads of departments in different departments of psychiatry in Pakistan, and how to develop a training program with an accredited university. So let's begin. I'd like to thank Dr. Afzal Javed Saab, who's the president of the World Psychiatric Association. I've been linking with him, especially since last year, in developing a training program to benefit our colleagues and friends in Pakistan. Thank you to Professor Imran Ijaz Haider, the chair of the scientific committee, and also the organizers for this conference. And lastly, I have no conflict of interest to disclose. Now, forensic psychiatry around the world, the definition, the simple definition would be an interaction between psychiatry and the law. And that law can be mental health legislation, can be criminal law, and can also be administrative law. This definition encompasses some of the key pillars within forensic psychiatry, including psychiatric evaluation, specialized psychiatric treatment, legal regulation, and education and research efforts. The first two parts of that, psychiatric evaluation and specialized psychiatric treatment, is one of the key components of what we do. Our job as a forensic psychiatrist is to take a detailed history from the patient, from collateral information, from the potentially even from victim statements, and we synthesize that information and overlap that information with the existing legislation and provide an opinion to the court as to whether this person, due to their mental illness, can potentially get relief from the courts or not. So a good report will not just provide that information. A good report would also say, if the court finds the person acquitted, then potentially they should go into a hospital, or if the person is found guilty, then in hospital these are the kind of things that are required. So that's what a good thorough report will show. So a very brief 2 slides on the history of forensic psychiatry, but this is mainly in the Western world. So in the Western world, legislation has gone far back as the 1700s, but where things made a change is, as in most jurisdictions around the world, is when there's a high-profile case. High-profile cases usually tends to lead to changes in the law. Similarly, in the 1800s, a gentleman by the name of James Hadfield tried to shoot the king, and this precipitated an act for the safe custody of insane persons charged with offenses in 1800, and this was commonly known as the Criminal Lunatics Act. 40 years later, a gentleman by the name of Daniel Macnaghten from Scotland suffered from delusions of persecution, and he intended to kill the then Prime Minister at the time, Sir Robert Peel. However, inadvertently, he ended up killing his first secretary, Edward Drummond. Now, Mr. Macnaghten was subsequently found acquitted due to mental disorder, and Queen Victoria was very upset at the time and asked her House of Lords to look into that verdict, similar to the Supreme Court. The House of Lords then came up with the law described as the Macnaghten Rules. Now, the Macnaghten Rules talks about that if an individual commits a crime due to a disease of the mind, and at the same time they were unable to understand the nature and quality of the act, and if he did know it, that he did not know what he was doing was wrong, then a defense of insanity can be established. So in a situation like that, a person has to be suffering from a disease of the mind, a mental disorder, at the time of the offense being committed. And they have to be able to prove one of two things, or even potentially both. The first thing is that as a result of the disease of the mind, they were unable to understand the nature or appreciate the nature and quality of what they did. The nature and quality is actually the physical act, whether it was shooting them, using a sword. If they knew the mechanics of what they did, that is the nature and quality. More times than not, people are usually found not criminally responsible because of the second test, and that's the wrongfulness test. If they were unable to understand what they did at the time was wrong, so wrong is in the light of mental illness. So a person with delusions of persecution may feel that they have to kill such and such person for their own protection. That could be a potential defense in such situations. Now, the Quran and Hadith lend heavily in the jurisprudence in Pakistan. All offences in Pakistan are enshrined in the Pakistan Penal Code, and the Code of Criminal Procedure is basically the manual and a guide what judges are supposed to do in certain situations, in different types of cases. So this is one of the amazing hadith, again, in relation to forensic psychiatry in Pakistan, is that the pen is lifted from three: a child until he reaches puberty, an insane man until he comes to his senses, and one who is asleep until he wakes up. Now, I proudly display this hadith to in all of my conferences internationally, and people are very amazed by this. Now, one would say that the first two are fairly straightforward in an ethical sense: a child until he reaches puberty, and an insane man until he comes to his senses. But what stunned me the most when I first came across this hadith was the third point: a person who is asleep until he wakes up. Now, it's only in the Western jurisprudence that, especially over the last 40 to 60 years, that homicides committed during sleepwalking have come to the attention of the courts. So this hadith has, as with the Quran and Sunnah, stood the test of time. The definitions of mental disorder in the Code of Criminal Procedure, the CRPC, or the Pakistan Penal Code has been varied and has been criticized by the Supreme Court. Lunatic, insane, unsound mind have all been in different numbers within the Code of Criminal Procedure and the Pakistan Penal Code. When you look at the UK legislation, over time this has changed. So from lunatic, it was changed to person of unsound mind, and then to mental illness. Now, this is a picture of a gate towards a prison, and the symbol is very important in that when an accused, somebody who commits a crime, once an FIR is put together and a challan is put together, the procedure in court, the first step, the gateway into the criminal justice system, should be an assessment of that accused person's ability to understand what are they being charged with. Do they know what crime they're being charged with? Do they know what are the consequences of saying or admitting to guilt? Do they understand that process in court? What does the judge, the public prosecutor, the defense? So that general understanding and awareness is a fundamental right for any accused, no matter how grave the crime is, for them to be then tried in a just way. So that assessment is described in different jurisdictions around the world, but the fundamental concept is the same. Capacity to defend, fit to plead, fit to stand trial, or competence to stand trial generally is the same thing. However, the threshold, legal thresholds, can be different in different jurisdictions. In Canada, we have a test, and the test is that if, on account of mental disorder, if you focus on the last 3 points, if the person with a mental disorder is unable to understand the nature and object of court proceedings, consequences of court proceedings, or communicate with counsel, if they do not fulfill any one of these, then they can be found unfit to stand trial or incapable to defend. And if that's the case, then the law has to take certain steps. So understanding the nature and object of court proceedings talks about the general aspects of court. What does a judge do? What do the different court officers do? What does it mean to be found guilty, not guilty? And then understanding the consequences is what I mentioned, is if I plead guilty, what does that mean? If I plead not guilty, what does that mean? Having a basic awareness and being able to communicate with one's counsel. So you can understand that if a person has severe schizophrenia, severe bipolar disorder with mania and psychotic features, then they may not be in a position to instruct their counsel. And they should be the ones to make that determination. And very frequently what happens is that family members get involved, and it's a fundamental right that the accused should control as much of the trial as possible. So this is a fundamental test, and the Supreme Court has highlighted the importance of this. The Code of Criminal Procedure has a section 34, lunatics, from 464 to 475, and it deals with the issue of capacity to plead and criminal responsibility. In section 464, if a magistrate has a reason to believe that the accused is of unsound mind, the magistrate should then inquire into the fact whether this person is incapable of making their defense or not. And if the magistrate from the civil surgeon feels or believes that the accused is incapable of making their defense, then the court proceedings should be postponed. So what happens in the meantime? Then in the meantime, there has to be a mechanism by which this person's mental illness is treated, whether it's schizophrenia, bipolar disorder, and it is treated to a point that they do return back to a state where they can understand the court process. And then the criminal proceedings will continue where it's left off. Again, all of this process is already within the Code of Criminal Procedure. The problem is it hasn't been acted upon, and the Supreme Court has identified this and has made serious directions. The second important question is the issue of criminal responsibility. Article 84 of the Pakistan Penal Code talks about the act of a person of unsound mind. And if you look at the wording, it's a mirror image of the McNaughton rules. So I'll repeat, if a person is of unsound mind at the time of the offense, is incapable of knowing the nature of the act or the wrongfulness of the act, then at that time it is not an offense of what they have done. And understandably, public opinion, public concern that if a person with schizophrenia kills another person, how can they be set free? This is where education of the judiciary is also very important. And it's very important that when we do provide information to the court, we also can potentially provide opinion on alternatives. So if an accused is still a significant risk to cause harm to the public, then mental health laws, provincial mental health laws, should be used in those situations. Now, it is important to understand that providing expert opinion again, is the job of experts. And it is the court that determines who is an expert opinion. So whether it's an expert opinion on fingerprinting, on pathology, on various other things, the courts ultimately determine who is the expert witness. So if there's two psychiatrists giving expert opinion and the Qanun-e-Shahadat order replaced the Evidence Act, if you have two people giving expert opinion, one has been trained in forensic psychiatry, one has not been, the courts will take the forensic psychiatrist's opinion in greater regard because of that level of training and understanding. Hence, in the third part of my talk, I'll be talking about how we can work together to develop training programs in your department, whereby we would help train your team, and then onwards you will take that beacon forward. Now, the Supreme Court of Pakistan's judgment has hit the news worldwide, and it was a very proud time, I have to say, in my career as a forensic psychiatrist, and from the outside looking at how my friends and colleagues have been working in different jurisdictions around Pakistan, interacting with lawyers, interacting with judges to try and help mentally ill people. And even our neighbors to the east in India had some positive words to say for once about the Supreme Court judgment. So what I'm going to do is I'm going to deconstruct the Supreme Court judgment into four main components. So, definition of mental illness, the courts dealing with the accused, whether they're incapable or not. Can the court form a prima facie opinion on capacity to defend, and whether a mentally ill condemned prisoner should be executed? Now, the first line of the Supreme Court judgment for me was the most crucial and sets the tone for the entire judgment. And that is that the mental health of a person is as important and significant as his physical health. So for the first time, and especially in the courts, mental health and physical health are put at par. And this is critical. And remember in the past where I think a description of schizophrenia in the Supreme Court was taken in a different light. Again, this is where education for us as psychiatrists and for the judiciary is critical. So let's talk about the first component of the judgment, and that is the definition. Now, the Supreme Court had looked into various definitions, and again, I have to add over here my sincere thanks to Professor Modat Rana Saab, who was amicus curiae, friend of the court, providing that information to the court, which was critical in the judgment that we saw. And this is a landmark judgment which will mold forensic psychiatry at least for the next 2 to 3 decades. So coming back to the issue of the definition, there are various definitions and various terminologies, as I mentioned: lunatic, unsound mind, insane. So the Supreme Court took notice of this and directed that we look at the ICD-10 as a source for those definitions, and we replace all these different terminologies, unsound mind, lunatic, insane, with either mental disorder or mental illness. And thankfully, to put an end to the archaic term lunatic forever. The second component of the judgment looked at the issue of capacity to defend. This, as I mentioned before, is the gateway into the criminal justice system for anybody. And the courts directed that the defense, the public prosecutor, should take these matters seriously. Also, the judge should also understand that even if they are able to make a prima facie opinion that the person might be incapable, prima facie basically means on the face of it. So if on the face of it, an accused is presented in court and the judge feels that the accused might be suffering from a mental disorder, the judge still needs to inquire from a medical board as to the capacity to defend for the accused. So here the Supreme Court has said that medical opinion is sine qua non, meaning is essential in such an inquiry. Another very important statement from the judgment. So, up until now, medical boards provide a fairly good report, but it's generally focusing mainly on the diagnosis. What the courts ask for in future, what the Supreme Court has directed, is that it has to be a detailed and structured report, and that the head of the medical board can be examined by the court by either the defense and by the prosecution. So this will, I believe, help improve the quality of our reports. And again, as I mentioned, the court report is not just the data that we gather, it's also a synthesis and overlapping with the legislation and an interpretation for the court as to whether that individual can potentially get relief or not. Hence the importance of now and how critical it is for us to be moving to the next stage of forensic psychiatry in Pakistan. And here the word civil surgeon, medical officer needs to be replaced by the word medical board. This to me, and if I'm not mistaken, please feel free to email me and correct me, but I don't find any, up until this judgment, the medical board was not mentioned in any of the legislation. So if I'm correct in saying that this judgment has formalized the and validated the existence of the medical board system. Also, that the medical board should comprise of qualified and experienced psychologists and psychiatrists. So it's very important that as psychiatrists we up our game with this. The fourth and final key area this judgment has addressed is whether a mentally ill condemned prisoner should be executed. Now, a mentally ill condemned prisoner could become mentally ill one of two ways. Either during their incarceration they developed a severe mental disorder, or they had a severe mental disorder before they were condemned. And it is still possible for a person with mental illness to be condemned. So a person with schizophrenia could still, even though they had schizophrenia, understand what they did was wrong or appreciate the nature and quality of what they did. It is still possible. So it's just because a person suffers from a mental disorder, it is not an automatic get out of jail card. So the Supreme Court is now asking or directing the medical board to understand a test. This test is the rationale and reason. So if at some point there's a challenge, this will ultimately go to the Supreme Court again for the Supreme Court to try and explain what they mean by rationale, comprehend the rationale and reason. For now, it is up to the medical boards to determine themselves what they think comprehend the rationale and reason means. However, the Supreme Court was clear to say that not every person with mental illness will automatically qualify from this exemption. So this will require an assessment by the medical board and requires thorough examination to determine whether the condemned prisoner is able to appreciate the rationale. And this is important. There are two words we use in our jurisprudence. One is understand and one is appreciate. Understand is the basic level of awareness. I provide you with information, you understand what I've told you. But appreciate requires your frontal lobe. It requires being able to weigh things in the balance, the pros and cons. What are the risks and benefits of the options I've provided to you? So appreciate is a higher level of functioning. Understand is a basic level of understanding. Okay, I'm now moving into the last part of my talk. So I've been working with the Pakistan Psychiatric Society for now 5 plus years. I've also been working with the Federal Judicial Academy. I've done multiple talks for the judiciary. Last year I did a Zoom talk for I think over 200 subordinate judiciary members, district session court judges around Pakistan, very warmly received, and they too identify that this is a critical time for improvement in education by the different provincial and federal bar associations. I've been beginning some work with the Justice Project Pakistan. They're a group of lawyers. This was founded by Sarah Bilal, who's an Oxford graduate and a lawyer, and she's done some amazing work. And it was actually her team's efforts, along with the Professor Maudud Rana Sahab, that were instrumental in this Supreme Court judgment. So hats off to them. And also Dr. Afzal Javed Sahab, our president of the World Psychiatric Association, he took office last year, and it's a matter of pride to have a Pakistani at the helm, and he's also actively working with our team in developing some training programs. So I'm very grateful for his intervention. Just a very brief, so I've been working on this. I put some recommendations to the Pakistan Psychiatric Society in 2017 at the Hyderabad conference, and that we need to create a section of forensic psychiatry. Within psychiatry, we need to create a group of people, like-minded individuals, who will take these challenges, education, training forward. So Alhamdulillah, Professor Afridi Sahab was working diligently during his tenure, and in December last year, the forensic psychiatry, in addition to multiple sections, were created. The next step, and this is the crucial step, is that we need to get these sections activated and meeting on a regular basis. COVID has hampered a lot of efforts that we've been trying to do over the past year, but as hopefully, inshallah, we move out of COVID, we need to begin work on this important section. So some key recommendations is that the College of Physician Surgeons of Pakistan and magistrate exams needs more forensic content. So I'm more than happy to provide the CPSB with some questions and answers on some multiple choice questions on forensic psychiatry for Pakistan. And I'm also working with the provincial bars to look at how to provide some exam content that has more mental health material in it, because that is the entry point where people usually tend to study hard and develop an awareness of mental health. We need some better training, existing psychiatrists, lawyers, judges on all aspects of forensic psychiatry, including report writing, giving testimony, and legislation training, because now with the Supreme Court of Pakistan's judgment, these are the skills that are going to be required moving into the next couple of decades. And also looking at creating stronger links between psychiatry and the law, and perhaps inviting or having a joint conference on forensic psychiatry in future. I understand there was one forensic psychiatry conference done in Lahore a couple of years ago, but hopefully perhaps having psychiatrists present at law conferences and having lawyers present at psychiatric conferences will help build some bridges. So I'm coming to my request, and again, this is a huge request to all of you, but especially to the heads of the departments listening to this talk. I'm applying for a grant from the Royal College of Physicians and Surgeons of Canada, and this is a grant specifically on medical education for low middle income countries. So I would like to apply for a grant that would allow me and a team from here to come to Pakistan, but also when we are not in Pakistan, help different departments across Pakistan develop an accredited forensic program with your own affiliated university. I feel that would be a better step initially to develop, to trial, to test, to improve, and then in future develop a subspecialty with the College of Physicians and Surgeons of Pakistan in forensic psychiatry. We have the support here from the chair of the forensic division of the Royal College, and he's very excited to be on board. His name is Dr. Brad Booth, and he said that he would love to come to Pakistan and help in this endeavor. So my request is that we would like you to be on board. I'm putting together this application in the next 3 to 4 weeks. The submission date is the end of August, and I would like to specify which departments and which heads of departments are expressing interest. We would like you to be the expert opinion and being trained by the experts. And this is something psychiatry and judiciary need to improve their training on. So this is a critical time, especially with the Supreme Court judgment. I've been presenting this topic for a number of years, but it's only once the Supreme Court gives their stamp that this needs to happen. All levels of whether it's within government, legislation, within judiciary, there's a lot of teaching going on. And again, Group Development Pakistan is another big organization that's been doing some amazing work with the youth offenders as well. So I invite you to come on board. So I'm asking especially the heads of the departments to engage with your departmental members. Find those people who have been doing this work on a regular basis. This will require some time commitment. We can offer the expertise, but your team will be the ones applying for this accreditation from your respective universities. Once, and inshallah, if we do get the funding, then I can then bring a team with me to Pakistan and spend a day and a half at each institution for that didactic training. And after we leave, we will stay in contact in developing your respective programs. This is a really good opportunity. I really hope to hear from as many of you as possible. So please take down my email address, Hassan T, HASSANT @providencecare.ca. I didn't put my number there. You can take it down, 613-453-7023, and it's on WhatsApp. A few of my colleagues probably sitting there, my friends I should say, should have my number in case that you haven't been able to write this down. So that comes to the end of my presentation. I really hope you enjoyed it. I hope the sound quality this is actually my second recording. The first one, the sound quality wasn't too good. So I do hope you were able to bear with me, and I appreciate that you took the time, your 30 minutes to listen to my presentation. I always like to hear from you, ideas, thoughts. If you have cases you're having difficulty with, I'd be happy to provide some informal advice as well. Please do dua for me and my family, and I appreciate your time. Wassalamu alaikum rahmatullahi wa barakatuh.